Welcome to Prediction News Update. My name is Chris Gerlacher. I'm the senior political reporter and industry analyst for Prediction News, and we are coming off the Third Circuit oral argument, Kalshi versus New Jersey. And we've got ourselves a man on the inside. Before we get into that, make sure to follow us on X at Prediction News, like and subscribe to our YouTube channel at Prediction News, and let's get right into it. We're going to bring in Daniel Wallach. Dan is an appellate lawyer, and he was there in the courtroom listening to the arguments in person. Dan, you've talked before about being able to tell how the case was going to go, just by being in the room and feeling some of the vibes with the panel judges. What were the vibes during both sides' lawyers' arguments?
Well, I mean, you could tell where the argument was headed in terms of the momentum with the first sentence uttered out of the New Jersey Solicitor General, Deputy Solicitor General Stephen Ehrlich. Mm-hmm. He let in, I mean, this is like coming on the heels of Maryland's federal court ruling, mm-hmm. which went the state's way and focuses on the presumption against preemption and drills down on congressional intent. This lawyer from New Jersey almost acted as if the Maryland decision did not exist or it existed in a vacuum. He let in with his prime argument being the definition of a swap, not being inclusive of sports-related event contracts. And that's really what you're doing is almost you're conceding the ground on the applicability of the Commodity Exchange Act by diving into the minutia of the substantive definition of what a swap or a commodity is. At a higher level, the New Jersey Deputy Solicitor General should be arguing that this framework doesn't even come into play because it's not what Congress intended for all the reasons laid out in the Maryland court ruling. So the moment he led with the definition of a swap, I'm messing up his first name, Judge Chigaris, he's the chief judge of the Third Circuit, who sat in the middle and was sort of the lead judge. He was the point guard today. And he said, counsel, the definition of swap is quite broad. And when you look at the definition of swap in a vacuum, it can include everything, anything beyond the control of the parties, any event, occurrence with a potential financial, commercial, or economic consequence. And that kind of language, you could drive a truck through. And if you read that in a vacuum, if you're a strict constructionist, if you're Judge David Porter, who was appointed by Donald Trump and went to Antonin Scalia's law school at George Mason, he's going to be a strict constructionist. He's going to focus on the statutory language, the plain language. And under that reading in a vacuum, without considering anything else, the legislative history, what Congress may or may not have intended, it's an uphill battle for New Jersey, and that set the tone for the remainder of the oral argument. It was 15 minutes per side, and if you're wondering why I go there in person, you just get a feel for things that sort of transcends just watching it on YouTube, where you may be watching it passively, may not be paying attention to how the other judges are reacting. It's important to take in all the surrounding circumstances, and there's an excitement and a palpable feeling of excitement when you're in that court. So I feel it was worth the long journey from Fort Lauderdale to Philadelphia, and it didn't take long for most of the observers in the court, anyone with a law degree who was there as an analyst. I think there were a couple of folks there. We all kind of came away with the same feeling that this seems to have gone very well for Kalshi.
And how did the vibes change when Kalshi's lawyer got up to begin arguing? Because that did seem like it went well, even over the audio on YouTube.
Well, it went well for Kalshi and for that lawyer before they even got up to the podium. I mean, the New Jersey Deputy Solicitor General walked right into the swap trap. And gave the court basically the opening to, sort of examine how broad the statutory definition is. And Kalshi's lawyer, I think William Haverman, he was on point. He was terrific, very smooth. I give his presentation, delivery, substance, close to 10 out of 10. He was right on point. But so is the New Jersey Deputy Solicitor General. The difference is, they each focused, the New Jersey side focused on the wrong thing, in my view, and emphasized the legal point that I think is Kalshi's best argument, which is how broad this definition of a swap is. So I'm not saying it went entirely Kalshi's way today, but it seemed pretty apparent based on the questions that came from Judge Chigaris as well as from Judge David Porter. The third judge, was appearing remotely, and she didn't ask any questions. I believe that's Judge Roth. So can't read into her line of thinking, but at least with the two active judges who were somewhat a hot bench, most of their questions seem to be, looking at things from the perspective of Kalshi, although Judge Porter did want to get into some line drawing. He kept repeating the question that I don't think Kalshi's attorney adequately answered, but he asked multiple times, can you give me an example of a sports bet? He uses the word sports bet. Can you give me an example of a sports bet that's not a swap? And he must have asked that question at 3 or 4 different junctures. So I surmise that it's a very important point for him. And Kalshi's attorney responded that, yeah, I guess player props would be the kind of sports bets that fall outside the definition of a swap. And it seems like a curious answer in light of Kalshi's recent foray into player prop bets. So it suggests to me that the court is somewhat sympathetic to New Jersey's plight as to having the entirety of sports betting shoehorned into the Commodity Exchange Act, and there may be some effort by the court, in its opinion, to set forth some lines of demarcation between sports bets and sports event contracts, that it can't just subsume the entirety of sports betting. And where that line is drawn, I suppose player props might be a starting point.
Or even certain player props. Could there even be a line drawn among those types of wagers as well?
I don't think so, because the player props, unless we're talking about an Olympic athlete going for the gold medal in an international competition where there could be worldwide economic consequences associated with whether he wins the gold medal and his country wins the gold medal, there could be limited instances of player props or individual player performance having the kind of economic consequences that are economically intrinsic and not just unique to the player. But the problem with line drawing is, how can you even begin to draw a line, because you cannot conceive of every example under the sun? What is this? So the Super Bowl is okay. So is it the NFC Championship game okay? How about a regular season game? How about the NBA regular season? How about hockey? And the fact that these questions even have to be asked as to where the line is drawn. Some events have greater potential economic consequence than others. Some may have none. I mean, there are some games, especially with hockey, they may not even be televised. They may not even be on the radio. So I think that might be an inherent dilemma for the court in trying to delineate some rules for the road, if they're even going to endeavor to do that. I mean, they're being asked to either affirm or reverse the motion, the preliminary injunction. They're not being tasked with writing a rule book. And so it's really interesting and intriguing to me to see where the court goes here, because on the one hand, it went pretty well for Kalshi, but on the other hand, the court does have some reservations and concerns about how far to take this.
Well, let me ask you this too, because a point that Kalshi's lawyer made, I believe, near the end of his arguments, these two products could, in theory, exist in parallel. The on-exchange products could be regulated by the CFTC. The off-exchange products could be regulated by the states. And from a legal framework in his reading, there's no conflict here. Could the court agree with that?
Yeah, but the problem or the dilemma here is, the court can always, accept the notion or rule that sports betting outside of DCMs is regulated by the states. On DCMs, it's regulated by the CFTC. But it opens up a whole Pandora's box of all these customer protections, KYC, sports-related integrity protections, suitability issues, consumer protection issues that are not, in the CFTC's wheelhouse, at least when it comes to sporting events. I mean, they do price manipulation and, their 23 core principles, but their architecture as presently existing does not encompass anything relating to sporting events. So are they well equipped to do that? If you just look at this in isolation, I suppose definitionally and logically, they can exist side by side, but sporting events have always held a very special place in Congress's mind as being so sacrosanct because of issues of problem gambling, match fixing, teenage gambling, All those issues led to the passage of the Professional and Amateur Sports Protection Act in 1991. And with the reversal of PASPA, those issues don't go away now. And it just seems to be, it just seems to be that you can't look at this issue in a vacuum as a technical definition without addressing the broader consumer protections that are addressed by state sports betting laws that simply don't exist yet on a federal framework. And I think it's lazy. And I'm not backing off the predicted result here, but for the court to say, I think it was Judge Chigaris who said continuously, well, isn't this something that the legislature should be fixing? I mean, I have my notes here. I want to use these exact words, but early on, he said that isn't it a fix that's left for the legislative branch of government? Said that multiple times. And so all these significant issues that undergird PASPA and state sports betting laws of consumer protection and sports integrity and match fixing and responsible gaming, those are areas that Congress should be left to address and provide some guardrails, and not for the court to weigh in here and decide that the CFTC is an inadequate agency to oversee this kind of activity. But this is not pork, this is not corn, this is not wheat. Right. This is sporting events which have always had the had the risk and history, multi-decade history of people trying to fix matches. And that's why it's imperative to have a strong state regulatory framework to safeguard against some of these risks and ills. And so far, it's been working on a state level. And whatever episodes of integrity violations or restricted bettors making bets they shouldn't be making, all those get flagged because regulators with the state work hand in hand with sports betting operators and their integrity watchdogs. Who's doing the same thing at the CFTC? Who's cooperating with Major League Baseball? Who's cooperating with the NBA? Nobody. So from a policy perspective, I think that has to be front and center, and that needs to influence the judicial decision-making because of the history of PASPA and how it came to be enacted, and ultimately why it was reversed. You can't treat sports betting like every other commodity if it is in fact a commodity.
Okay, so even if Kalshi were to go to the lobbying route in Congress and get an amendment to clarify that the CEA can't include sports, you still have concerns about, say, data sharing with the leagues and some of those common practices, right?
Well, I mean, if Kalshi were to go to Congress and say, hey, just add a line, let's redline the definition of swap to add 3 words, sports event contracts, that can't be the end of it. If Congress is going to place its hand on the sort of the entire framework, it needs to build in some guardrails and protections almost akin to what a federal sports betting framework would be. It can't just in a very cute way tweak the definition of swaps to make clear that this type of activity is allowed. It has to build in the same type of architecture that state sports betting statutes encompass. So I think there's an opportunity here. If Judge Chigaris, I mispronounced his name as Chigaris, but if Judge Chigaris is right that this is a fix for Congress, the court's going to deny or affirm the preliminary injunction and leave the ruling intact and force the states, force the operators, force Congress to deal with this issue. But as it stands today, this is one court, one case. There are going to be other circuit courts of appeal weighing in the Fourth Circuit and eventually in the Ninth Circuit. But this is the most consequential point in the entire Kalshi controversy. And if Kalshi were to secure a victory in the first federal appellate court to rule on this issue, that is a seismic event that could ensure Kalshi's longevity, or at least the vitality of sports event contracts for at least several more years, unless and until the Supreme Court overturns it. So a Third Circuit victory would fortify Kalshi in the present, both in New Jersey, and it could have influence, and it could have a precedential or at least persuasive effect in some of the other courts that are hearing the case. But ultimately, for me, this comes down to, how are you going to argue this issue if you're the states? Are you going to get into the weeds of the CEA and argue as to what is a swap and what is not a swap, or are you going to deal with it at a higher level from what what congressional intent entailed, and is this the kind of activity that Congress intended to be traded on derivatives markets in light of the legislative history of the statute and in light of Kalshi's own prior statements?
Are you going to argue Kalshi's strongest point for them?
Yeah, that's essentially what New Jersey did, and it ties back to a theme that I've been harping on from day one for an industry for sports betting, which is essential to the gaming industries in states all over the country and is a major economic driver for these states. Why are they not hiring law firms that are of the same caliber as Kalshi's lawyers? Kalshi has brought in Milbank, which is a top 20 law firm, top tier litigation firm. They had 5 of them sitting in a row all together. I felt like I was watching the New York Yankees. They were just sitting there as sort of this powerhouse team. And the New Jersey Attorney General's office was basically 2 lawyers. They were outside milling around in the hallway. They were late to the podium. This kind of, with the stakes at issue here, which is billions of dollars of economic value to the casino industry, the sports betting industry, hundreds of millions of dollars annually to the state in terms of tax revenues and licensing revenues. Why wouldn't you hire a Top Gun mega law firm to go head to head with Milbank? And so far the results speak for themselves. 2 out of the 3 court rulings have gone Kalshi's way, Maryland being the exception. But I just can't understand why the states and why the licensed gaming operators are leaving it to governmental attorneys to do battle against Milbank, instead of bringing in someone like a Paul Clement or a Ted Olson type of lawyer. Ted passed away last year, but you need best of the best to argue complex federal issues that deal with field preemption, conflict preemption, these esoteric federal issues and constitutional issues that are right in the wheelhouse of these sophisticated mega law firms that may be a little bit too out of the ordinary for a state attorney general's office. And I think it's showing.
So the standards of review are this really vital battleground, because I feel like that's some of the inside baseball that the attorneys will recognize that the ordinary viewer won't quite get. I mean, what are some of the standards of review that need to be looked at here, or that are being followed?
That's pretty much it. But generally, when there are appellate oral arguments and you're trying to change the result of a trial court, most trial court judgments come to the appellate court cloaked in a presumption of correctness. And there's a heightened standard of review to overturn a lower court result, which makes the job for the appellant all that much more difficult, because you have to show it was arbitrary and capricious, or it was not supported by the clear weight of the evidence. The lower court ruling comes with this force field. But in the Kalshi case, there were no such presumptions. It was a de novo standard of review, meaning that the appellate court was free to look at the issue anew without according any weight or any deference to the lower court's ruling. And when you combine that with the presumption against presumption against preemption, it should have been New Jersey that had the upper hand initially, because the burden would have shifted to Kalshi to demonstrate, to point out how Congress demonstrated clearly and manifestly that sports betting was intended to be conducted on the derivatives markets. And you can't point to the definition of swap and say, well, that's it. It's there. The definition of swap says nothing about sporting events or casino or prop bets. It's just this vanilla, open-ended definition of potential economic, commercial, and financial consequence. The argument here is for Kalshi to be able to pinpoint where congressional intent is clear and manifest as to the topic of sports betting, and not just simply as to the overarching topic of regulating contracts on DCMs. I mean, Kalshi wants to view the issue of this case much more broadly, and that if the CFTC has exclusive jurisdiction over contracts traded on DCMs, they should win. No, the question, at least as it's framed by Judge Abelson in the Maryland case, is you got to drill down on the issue of sports betting and this particular product. And that point wasn't made today by New Jersey, nor was it properly articulated to the court.
Well, let's look ahead to.
I mean, that's the win. I mean, Kalshi will get an affirmance here with the possibility of some line drawing by the court.
And then how do we get from there to a potential Supreme Court case? Because if the state loses, they'll certainly appeal to be heard before the Supreme Court, right?
This is the last appeal. When you go to the U.S. Supreme Court, it's called discretionary review. There's an automatic right of appeal to go from the district court to the federal court of appeal. So what will happen here from a timing perspective, I think the court is going to, because this is an expedited appeal that was heard and argued fairly rapidly within a few months of the filing of a notice of appeal, I would expect a decision to be rendered before Thanksgiving. Okay, so the decision before Thanksgiving, would lead to what's the next step after this. If it goes Kalshi's way, as I expect it to go, the next step would be not the U.S. Supreme Court, but for the state of New Jersey to file a petition for rehearing en banc with the Third Circuit and ask the entire Third Circuit, all of the sitting active judges, all of the sitting active judges on the bench, not just the 3 judges, but all of them, to sit and rehear this case. And there's precedent for that in the Third Circuit. Christie versus NCAA, or NCAA versus Christie, the sports betting case that was ultimately decided by the Supreme Court in May 2018. That was one of the few instances in that calendar year of 2016 where the Third Circuit granted a rehearing en banc and gave New Jersey a second bite at the apple. And I would expect that to happen here. You can't say expect when the percentages, given past history, you're talking about single-digit percentage likelihood. But I think this does line up to be a very checks all of the boxes for the type of case that would garner en banc review. It's a case that has national significance, divided rulings among courts all over the country, and even within the Third Circuit. I would also look to see whether there's a 2-1 decision in this case. A 2-1 decision would be would more likely militate in favor of granting a rehearing en banc. So the next step for the losing party in this case, which will almost certainly be New Jersey, is to file a petition for a hearing en banc. That might take a couple of months or a month or two to either get denied or get granted, and then it kicks in a new round of briefing, and then it goes to the U.S. Supreme Court. So we're not going to be at the Supreme Court in calendar 2025, I suspect. I think we'll be dealing with the issue of rehearing November, December, and January.
Okay. And then after that, what is the timeline on a potential Supreme Court or an application for a writ of certiorari after the rehearing en banc?
120 days after the Third Circuit mandate issues, which is the final decision of the Third Circuit following rehearing, the non-prevailing party has 120 days to file a cert petition with the U.S. Supreme Court. Now, if, for example, New Jersey wins on rehearing, Kalshi would not just wait out 120 days.
Right.
They would immediately go to the emergency docket and file an emergency motion with the U.S. Supreme Court to have an injunction or a stay pending appeal to prevent New Jersey from enforcing their sports gambling laws against Kalshi. But if it goes Kalshi's way, as suspected, and if they win on rehearing or rehearing is denied, then I think it's just a 120-day waiting period. But this case will end up being petitioned to the Supreme Court no matter who the party petitioning the court is. And will the Supreme Court accept cert? I suppose it depends on the existence of a dissenting opinion, as well as how some of the other court cases around the country play out. If the Fourth Circuit and Ninth Circuit end up with rulings that are inconsistent with the Third Circuit ruling, that certainly heightens the prospect for the U.S. Supreme Court weighing in, granting cert, and then we go back to the drawing board in the fall of 2026.
All right. A lot of drama coming up. So I think that pretty much covers the Third Circuit. What are the next big legal dates and legal milestones in the Fourth Circuit, and potentially learning whether we hear this in the Ninth Circuit out of Nevada?
Yeah, on Fourth Circuit, there's a briefing schedule that's been established by the U.S. Court of Appeals. I think the first brief is due sometime in early October. There was recently an extension granted. I would expect there to be an oral argument in the Fourth Circuit U.S. Court of Appeals either later this year or sometime early in 2026. It's too early to project when that decision will be issued because we need to know the date of the oral argument. But the briefing will be done by Thanksgiving, I would imagine, and then oral argument within 2 months after that. Okay. Going to the Ninth Circuit, there's no appeal yet in the Ninth Circuit. This is the only one of the three cases where the state hasn't filed an appeal, or Kalshi hasn't filed an appeal. Nevada and Kalshi are still litigating in the trial court case in front of Chief Judge Andrew Gordon. And recently, tying back to my comments about hiring big gun national legal counsel, the state of Nevada brought in a national law firm to represent it, albeit a few months too late, but maybe not ultimately too late. But they should have done it early on. But now they're going to be represented by a heavy-hitting U.S. Supreme Court practitioner, which is what they should have been doing all along, which is what New Jersey should do now, and what even Maryland should be doing, notwithstanding their victory.
Right. Well, there's going to be a lot to watch. So we'll leave it there. Unless you had something to add.
Yeah. Nevada, there's also the issue of discovery, right? So
right.
The magistrate judge denied Kalshi's emergency motion to stay discovery. So we're going to have fact discovery taking place in Nevada, where the state is going to be asking for all sorts of sensitive documents showing communications between Kalshi and Donald Trump Jr., Kalshi and the CFTC, Kalshi and Brian Quintenz. There's going to be a lot of interesting stuff gathered during the fact gathering process in the Nevada court case, but that's going to proceed on a sort of acquired a path until there's a time where there's like motion practice over discovery, or there's a motion for summary judgment. But right now, the Third Circuit ruling looms as the most consequential event in the entire controversy. And if as expected, Kalshi wins or prevails here, at least at this juncture, that would be a tremendous boon to the sports prediction markets.
All right. Very perspective setting for us. So if you like what you heard today, follow us on X at Prediction News. Like this video, subscribe to our YouTube channel, also at Prediction News. Dan, as always, thanks so much for being here with us and traveling all the way out to court to get this in person.
I mean, it's fun to do that. I was last in this courthouse for the Christie 2 oral argument in 2016. There's really nothing like it to see. I mean, I was spoiled 10 years ago. I got to see Ted Olson go head to head against Paul Clement. Watching, Stephen Ehrlich do battle with William Haverman doesn't quite get the juices flowing as much as a Clement versus Olson battle did. But both of these lawyers today did a great job, although I'm somewhat puzzled by the approach taken by New Jersey.
Well, we'll be back soon with more legal updates. Dan, thanks so much.